Dear participants in the 10th GNLU International Moot competition, distinguished panelists, dear members of the organizing committee, my name is Nicolas Lamp and I'm an assistant professor at Queen's University Faculty of Law in Canada. I had the great honor to be invited to be the case author for the 10th edition of the GIMC, in which you have all just successfully participated. I very much regret that I was not able to join you for the competition. It would have been an immense pleasure to see your pleadings and to meet all of you in person. Fortunately, the reason I was unable to join you is a happy one. My daughter was born on 7th February, the day of the opening ceremony, and she and my wife are healthy and recovering well from the birth, and I still have my tag from the hospital. I'm grateful to the organizing committee for this opportunity to address you via video, and would like to share a few thoughts with you, first about the case, and then about mooting more broadly. When I was asked to write the case for this competition, I tried to come up with a scenario that would bring some of the best young minds in the trade law world, your minds, to bear on the complex legal issues posed by the WTO agreements as they stand. However, I also wanted to invite you to reflect on some of the difficult institutional questions that arise from WTO members' attempts to reform these agreements in novel ways. As you all know well, the case I came up with involved three claims in ascending order of difficulty. The first claim presented a straightforward issue of legal interpretation, namely, whether a tariff that is changed regularly by administrative action constitutes a variable input levy prohibited by the WTO Agreement on Agriculture. This claim was meant to allow you to draw on and apply the jurisprudence of the appellate body, the bread and butter of the WTO lawyer. The second claim raised more difficult interpretative questions, namely, whether the instruction to give due consideration to the influence of excessive rates of inflation in Article 18.4 of the Agreement on Agriculture has any import in assessing a WTO member's compliance with its domestic support commitments. The second claim also invited you to explore the broader institutional issues arising from the Bali decision. One of these are the effects of a WTO member's notification record under the Bali decision. Another one is the question of whether WTO members have effectively waived their rights to WTO dispute settlement regarding certain matters through the decision. The third claim posed the even more consequential question of whether WTO members can modify their substantive rights and obligations under the WTO agreement through a ministerial decision, or whether such a decision must be implemented by modifying each member's schedule to have legal effect. My hope was that these claims would, first of all, allow you to demonstrate your understanding of how the disciplines of the Agreement on Agriculture work, especially the interplay between the provisions of the agreement and the schedules. Second, I was hoping to draw you into the debates surrounding notifications, waiver of rights to dispute settlement, certification of schedules, and the legal force of ministerial and general council decisions that purport to modify substantive rights and obligations of WTO members. These are complex legal issues which remain largely unresolved. However, I hope that you have enjoyed engaging with these issues, and I'm eager to hear what arguments you came up with. Now a few words about mooting in general. I participated in a different moot court competition in WTO law, organized by the European Law Students Association in 2007-2008, exactly 10 years ago. It was my first in-depth exposure to WTO law, and it became my passion. Soon afterward, I decided to write my PhD on the lawmaking process in the World Trade Organization, and yet a few years later, I had the opportunity to do an internship at the WTO and to work as a dispute settlement lawyer at the Appellate Body Secretariat. The important part of this story for your purposes is that I was able to do all this even though my team did not win the ELSA Moot competition. Far from it. It didn't even make it to the quarterfinals. This shows that what may sound like a cliche but is actually true for mooting. If you're participating, you have already won. You have shown that you are able to work extremely hard to master a complex body of jurisprudence in a very short period of time. And you have learned to argue passionately about an area of law that may seem forbiddingly complex and dry at first. The type of commitment and drive that it takes to participate in a moot court competition will open doors for you as you take the next steps in your career. Anyone in the trade law world who sees that you have done the GIMC will know that you are serious about international trade law and will consider your application very closely. But more importantly, you should all be very proud of yourselves for what you have accomplished in the past months in preparing for this competition. While I regret that I cannot congratulate you in person, I hope that I will have an opportunity to meet many of you on another occasion, perhaps at a conference, perhaps when you're working at a law firm or at the WTO, or perhaps at next year's GIMC. Perhaps some of you are interested in doing graduate studies on a topic in international trade law. In that case, I would be delighted to work with you here at Queen's, and I encourage you to apply to our graduate program. In any event, if you have any thoughts on the moot problem or questions about graduate studies or careers in international trade, please do not hesitate to get in touch with me. Congratulations on all your hard work for the competition. Enjoy your last evening at the GIMC. Goodbye.